we had a bench conference in this case. In this case, I've been provided a plea form that indicates that the defendant will be pleading to an added count 2 of operating while intoxicated first offense. Upon a successful plea, the 93-day offense. Upon a successful plea to that charge, count 1, the second offense would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
That's our full understanding as well, Your Honor.
All right. May I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth so be God?
Yes.
Go ahead and state your name.
Michael Burke.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated first offense.
That's correct.
All right. That is a misdemeanor, punishable by up to 93 days in jail, up to a $500 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
All right. You signed an advice of rights form, is that correct?
I did.
Any questions regarding any of those rights?
No, I don't have any questions.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, they have not.
Has anybody threatened you orally?
I am.
Of your own free will?
Yes,
And because you believe that you're guilty of this offense?
I do.
On the date of May 23rd, 2025, at 3113 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
Do you recall what you had and how much?
Yes, it was vodka, 4 of those little shooter containers.
Okay. Were you stopped by the police or
It was a welfare check.
you were welfare checked in a parking lot
Yes.
at that address? Okay. And after the police checked on you, were you arrested?
I was brought to the hospital, but not arrested. I don't know if I was under arrest at the point I was in the hospital, but I was eventually.
You probably were. Fair enough. Ultimately, you were taken by the police and or ambulance to the hospital. Is that
Yes.
correct?
Yeah,
All right. And they gave you a blood draw,
they did.
and the blood draw was a 0.139. Is that correct?
Yep, that's correct.
All right. You have any reason to dispute those blood test results?
No, I don't.
All right. Sir, I do have to advise you between the time I accept your plea and the time of any sentencing that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation. The court would not be bound by that. You understand that?
Yes.
And you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
All right, court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be November 12th, 2025, 9 a.m. or as your invite indicates. Bond with its conditions will continue. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case. People versus Roman Hop.
Ashley Phelps for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hop. State your name for the record, please.
Ramon Hop.
Oh. I have before me a plea form that indicates the defendant will be pleading guilty to the charge of malicious destruction of property. 200 to 1,000, which is the 1-year offense, which I think is the stated count. On a successful plea to that charge, at sentencing, the prosecutor will recommend a probationary sentence And the victims are waiving any right to restitution in this matter.
That is correct, Your Honor.
All right.
That's our full understanding.
All right. Very good. May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Lower your hand, state your name.
Ramon Howe.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of malicious destruction of property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes,
All right. You signed an advice of rights form. Is that correct?
yes.
Any questions?
No,
No? All right. On the podium, you'll see a copy of one. Please look at paragraph 5, highlighted one. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Correct.
and of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
I'm sorry.
Yes, sir.
Yeah, okay, thank you. On the date of December 26, 2024, at the location of 2564 Deek Avenue, Pittsfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty?
I destroyed a statue and a doorbell camera.
Okay. And so this was at a residence that you did?
Yes, I used to live there.
Pardon?
I used to live there, sir.
You used to live there? Okay, but you don't?
No.
You didn't at the time?
Not for years.
Okay. And so you destroyed those things. You didn't have any property interest or ownership in any of those properties.
I had some property at the house stored, but I was there also that day to get that property back.
Okay, I got you. But as to the statute and the Ring camera, those weren't.
No, correct.
You didn't
correct,
buy either
No.
one of those, correct?
Correct.
Okay. And you didn't have the owner's permission to destroy any of that property or do anything to it. All right. And you did that intentionally, sir?
Yes.
All right. Would you stipulate or agree that the value of those two items combined was in excess of $200?
Yes. Like
That's-
excess or it was,
Yeah, it was more than $200.
$200 or more.
Okay, you would agree to that?
Yeah.
Okay. Sir, if I accept your plea in this case, I have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence agreement or evaluation in the case. You understand that?
sir.
And you would not be entitled to withdraw your plea. You understand
Yes,
that?
sir.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before satisfied.
Satisfied, Judge.
All right. Court will accept the defendant's plea to this charge. Count one. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
November 12th at 9 a.m.
November 12th, 2025, 9 a.m.
Your Honor, I know your next sentencing date is the 22nd. I know that's a quick turnaround, but given Mr. Hop's time he's done, we are asking for the 22nd.
His time is done.
He's been in custody for quite some time. He's eager to get assessed, get seen by probation,
Warehouse.
get this case resolved.
Go ahead.
We were also going to renew our bond request that the motion was on Wednesday, and this court denied that motion. He did want to renew that request. That housing is still, present for him. We just don't know how long it's going to be available. So that's why we're requesting such an urgent date.
I,
I do think he's still held on the felony, just so the court knows, Your Honor.
Yes, that bond's $100.
is he gonna be able to post that?
He thinks he may be able to. I mean, this is bond denied, so obviously this is driving the bond truck here.
Sentencing will be for the 27th.
The 27th. So the
Right, because he had violated the terms of his release, it's just why his bond was denied.
right.
The
He's gonna. I asked first.
I just don't think, and I can't. You're basically asking 3 days from now for probation to be able to interview him and do everything, as well as talk to the victims of this, and I just don't know that that's going to happen. I mean, if I set it for that day, I don't know that we're going to have all of the information that we need. So I'm going to set it for the 12th. That.
If also, so I'm sorry. I can talk to probation maybe if things are done quickly. We'll contact the court if depending on what Ms. Pilara can.
I just want to lose my housing.
Yeah, we're just really concerned about the housing issue, Judge.
No, I understand that, but I
For
also
6 years.
have to try to put things on a reasonable time frame and don't want to stress my probation department either. But
I will add, if I may, regarding the bond argument. I know the court said you would consider reach out to CMH to see what they recommended as for a mental health plan moving forward. The gentleman, Mr. Hop's caseworker, and just indicated that housing was their primary focus, that the CMH's mental health recommendation moving forward was to get him into housing. So they didn't have anything additional to add that he's already doing, which is he does report to CMH for medication. So I don't have anything else. I know the court requested that information. I don't have anything else to add except for that was their, primary recommendation for his, mental health journey. So again, that's why we're just trying to make things happen,
Yeah.
Judge. Obviously, the county has to do what they have to do with the housing, but we want him to be able to take advantage of it if possible.
anything else from the people?
No, Your Honor, I think I've made my position pretty clear to the court with our bond motion on Wednesday, and the court understands the struggles with secured housing,
Yes.
but also understands the struggles with bond violations that lead to new cases and all the things that are sort of going on in the periphery of that issue.
I don't see a basis on which I would change my decision. I think I would still keep his bond as denied. I'd like to see everything regarding his sentence and know as much as I possibly can about this. The events, as I understand them, are concerning to me, and then the violation on top of that adds concern. While certainly he would be going into Avalon Housing, you talk to CMH. First thing is, I'm not going to do anything until I see an absolute plan as to what some structure around him that's going to prevent further activities by him. So that's going to be one thing. But I also want to see the full outlay of it. And particularly, I want to make sure that the victims of this offense, that their views and what they might say to probation are fully considered by the court before releasing it. So I'm going to deny again the request for a bond reduction. All right.
I'll see what I can do.
All right. Thank you.
Thank you.
That it?
That's it.
That's it. Thank you.